Today marks the beginning of the international 16 Days of Activism campaign against gender-based violence. This year's program in South Africa comes after several months of heightened outrage and awareness around the abuse that women and children face. And today we ask, has the South African system done enough to protect children? We also consider what needs to be done to strengthen the child protection system. I'm now joined in studio by Miranda Jordan, Director of the Women and Men Against Child Abuse, as well as Lamprecht, the Child Protection and Development Specialist. It's good to have you both in the studio. Thanks for coming.
Thank you very much.
Thanks for having us.
I'm looking at this graphic. It's scary. Only 1 in 9 victims report. For every 100 reported victims who enter the system, only 8 victims will obtain a conviction. And that is a real question. And looking at your upside down triangle in terms of how this all filters, a big part is played by the community at the top in terms of the disclosure, in terms of the reporting. But I think this whole thing is sitting on the apex of the Department of Correctional Services, and they need to actually help us quite a bit. But let's talk firstly at the top, the disclosure and the reporting. It's said, Miranda, most of the times that the stats that we have right now are actually not a true reflection, because reporting sometimes actually goes unreported.
Absolutely. And I think so. Let's talk about the community, and let's talk where the community looks at issues around child abuse and reports child abuse. And let's just look at families who have, for years, we go back 60, 70, have historically protected child sexual abusers within the family for many reasons. So obviously, when a child discloses this, how does that affect not only the child's life, but the whole family's life? So, for instance, a child will say that about her father, her uncle, somebody in the family, and normally we're talking about 89 to 95%, it just varies in some places, that it's intrafamilial. So it's often somebody the child knows well, the child often likes him, but also is within the family and plays a pivotal role within the family. So here you have a case, the child now discloses maybe to a mother that this happened. What are the ramifications of that disclosure? First of all, we've got to have a look at the fact that this person, now it will be reported to the police. Sexual abuse, mandatory reporting under Section 54. The person will be investigated, arrested, start and enter into the criminal justice process. The family will probably be broken up, people will take sides, and in fact, the whole family will be broken. So that's the one thing. Then she enters the system herself, the child. Many parents apprehensive about entering a system that may take years. So do we go forward? Now, we may have that information. We could also deal with it personally. We could not go to the police. That is not a reported case. That's only dealt with within your family. So just in that small little example I've given you is already 2 big areas where people possibly would not go forward to the police.
And for the purposes of this conversation, though, look, we want to focus specifically on children and how they are filtered in the system, and what are the challenges that they come across, particularly when, for example, they go to the police and they report these cases, how they are treated in those facilities.
So what we found is that there's 3 primary points of entry for the child into the formal system, and that's generally schools, sports facilities, and faith-based organizations. So it's where children come a lot, and it's often where they get abused, but it's often where they disclose. Now, those organizations all have a mandatory obligation to report to police or social workers. The problem is when you get to the police level, you've got to they call them sort of client service centers, but they charge officers. Now, you've got a tiny little person walking in that someone in their family has abused them. The policeman says, "Where's your guardian? Where's the person who's supposed to be here to take the statement with you so that we're doing the right thing?" Or saying, "Oh no, well, we can't take a statement from you because there's no guardian," or "We can't do a medical examination and get forensic." Child victims specifically, because they need somebody to assist them to enter that system.
What are the barriers to enter in terms of the system itself? When we, for example, speaking about the Child Protection Act, what does it say? So that if the child comes into that situation and that's what they find, I mean, what recourse do they have?
So The police have to take statements from everybody, and they have to take from children. Now, what they try and cover themselves, they say, you need somebody who's a guardian. Now, if that person who is the guardian is actually the person who's doing the abusing, that is a very, very big barrier. Because what happens is the person that is the accused is the person who's also the person supposed to be caring for the child. So it's the person who's supposed to be helping with the statement is the person charged with the offence. So it almost circles in on itself and keeps the children out. The other barriers is that police officers are not trained to work with children. I'm talking at charge office level. They don't know how to speak to children. They don't understand children's language. They don't take children seriously. It depends on the age of the child. So if children are under 7, the police don't know what to do with them, because how do you take a statement from such a small child? If they're teenagers and they're naughty, they're just making up stories because they're older. So right throughout the system, there's a disincentive to enter the system, and it starts at the police. Once it comes to the court level, and the docket is actually now prepared, now that child has to give evidence. Like an adult would be cross-examined, because that person has a right to face the accuser. And the idea that that person is going to say you are lying because he is innocent until proven guilty, which means you are lying until you can prove otherwise. That's a big disincentive. So the idea of giving evidence first to somebody like a school, then you've got to go to the police and make a statement, then you've got to go to a doctor, then you've got to go to the prosecutor, then you've got to consult, then you've got to go to court, then they tell you you're lying. The whole system disincentivizes young people from coming forward.
Shall we take a practical case? Let's look at one case which is just wrapped up now, Nicholas Ninau case over here, and the Dross case. What were the things that you would say we did right, and what were the things that you say we did wrong, and what were the gaps, and how could we have improved that situation, that particular case?
Well, look, I mean, this was an acute rape that had just happened, and there were witnesses. So already that was, when we talk about how difficult cases were, that was on the easier scale, in the sense of that we were able to have witness accounts and that the child was found with all the injuries immediately. I think we had some problems with the prosecution, with the fact that the child did have to come and testify. But also, if I look at it, if he had not admitted, if there was not the public pressure and the public spotlight, we're talking about approximately 1,800 cases we work on in every year. And of those, maybe a handful have the spotlight and have public pressure. But if you don't have, like in this particular case, and you don't have a man admitting, you don't have witnesses, and this had happened somewhere else and not in the center of an urban area where there were all the facilities where, the child could be taken to a social worker immediately, the child could be examined immediately, where there were people that could support the child through the process, even though the child process was a harrowing process. And we still needed a very important information for the child to tell us that he had come in after her. So this was premeditated. And that obviously was for aggravation of sentence, that we needed to know that part of that. But if you take all the things that worked in favor in this case, this is almost... This is very unusual. When we look at the general systems we work with, generally a lot of our cases have to be taken forward. We've got 3 or 4 cases currently.
And most of them, they need a very strong investigative component, which is where the NPA comes in. What are the barriers to entry there? What are the victims facing when it comes to how these cases are investigated, especially when you're dealing with children in a situation where the event could have happened months ago and it is now reported at a later stage?
To link the offender to the event, so to the abuse. The medical evidence has to corroborate the fact that the child has said X has happened, and if there's a discrepancy, there needs to be assessments of the child. Then there needs to be an application so that the child can testify in a different court, and once need to be in place that in big built-up areas like Gauteng, much of that is available. Whereas when you start moving out into rural areas where you've got one prosecutor doing everything and there's not a pool of specialist knowledge plus specialist technology, specialist rooms, specialist equipment, we start losing the children at each level of that process. And then the cross-examination and protecting the child, as we have seen in many adult cases, protecting the children from cross-examination in a way that allows the cross-examination to occur, but without causing secondary trauma and sort of facilitating victim blaming.
Now in South Africa, one of the highest GVP rates in the world. Others would even say it's the economic rape of the world, capital of the world. Others are looking at the amount that we are spending on gender-based violence programs. I know in September there was a whole lot of noise that was made, forced the president to eventually say, okay, I'm going to give this thing a budget of 1.1 billion, and they came up with a 5-step or a 6-step program. But is it nearly enough? When you look at what the KPMG report says, gender-based violence is actually costing the country.
Because of the abuse that they've suffered and the fact that they can't get to facilities to help them with therapy, to help them heal. And from a very young age, we know how terribly abuse affects children's learning and their development. Then we're seriously looking, and when we look at the figures of approximately, it's been year on year for the last 10 years, approximately 50,000 reported cases, and we're talking about the 1 in 9. We really are looking at 500,000 and their families and siblings being affected by the abuse. So I think when you just spoke about the amount of money, I think we need to know that there are certain structures that are around and that need to be supported and need to be monitored, and who are in the industry. We do not need to reinvent this. What we need, for instance, we have Tutuzelas, we have one-stop centers, there are other organizations with one-stop centers that avoid some of the secondary abuse. They're not well managed, all of them. They do not have the right type of skills, and if we start looking at skills training and we start making it, ensuring that our prosecutors, whether they like it or not, and our magistrates are properly skilled. And if you are not, and you don't want to go through that, then you don't do cases that involve sexual abuse of children.
Look, finally, before I let you go, I mean, the president was speaking about making the sentences a little bit tougher. For example, negotiating for no bail for those who commit such offense, especially done to children, who are disabled. What's your position?
Look, I think that what we must acknowledge is that the criminal justice system is an open system, so at least we can monitor it. Secondly, I must laud the judiciary, because when the police and the prosecutors have done their jobs, the sentences we have got have been proper. I mean, the judiciary sent a very strong sentiment. The problem is then you get to correctional services, and what correctional services then decides to do is change the law to have a change of sentence, and then parole at half of your sentence. And there's nothing you have to prove to actually get parole. The victims have to come and re-testify so that you stay in jail. So I think when he calls for in his plan legislative and policy reform and enhancement, he really needs to look at correctional services.
Miranda, Luke, appreciate your time. Thanks so much for coming through.
Thanks for having us.